you get notices, whatever notices happen in your case will continue to be sent to you as well as to your client. So the notice of withdrawal is here as well. So you need to file that, and your client needs to sign the withdrawal also. I think that's true of everyone, of all the trial courts, and I don't know if that was made clear in the session downstairs. But not only does the client have to sign the appearance, the client has to sign the withdrawal. And obviously, if that becomes an issue between you and your client, you need to resolve that. And if you can't resolve it, then you'll have to come before the court on a motion. But that's part of hopefully the good practice you will have done in being clear with your client about what the scope of your representation is going to be and when it ends. And the client should not have an issue about signing the withdrawal. And one of the reasons I discussed how the trial works is that if you have a limited appearance for trial, you'll have to be clear whether you're going to withdraw at the end of the taking of testimony, or if you're going to continue to represent your client and prepare the post-trial briefs, which frankly I hope you do, because that's where the work of the lawyer is really important, or through closing argument or after the case has been taken under advisement, because strictly speaking, the trial's not really over until the post-trial briefs have been filed. So if you just say trial, there's going to be some question of when you can actually file your withdrawal. So keep that in mind in the land court. So one of the things, what I want to turn to now is, one other thing is we've included in our limited appearance LAR events, discovery events. Just as in Superior Court, we don't really, there's no discovery that happens in the court. You know, the judge isn't at a deposition. You don't file interrogatories with the court, etc. But you really can't represent a party in a discovery event unless you've appeared in the case. Certainly, I think Don would agree. If some lawyer just showed up to say, I'm here to represent the defendant in this deposition you're taking of the defendant, Don might say, who are you and where's your appearance?
Something like that.
So if you're being asked to do an LAR appearance for representing someone in a deposition, you'll have to file an LAR appearance in the court, in the case. And then once the deposition's done, you can file your withdrawal. So keep that in mind as well. So let me turn to some of the kinds of cases we see and how, at least from our view, where LAR would really be useful to us in those cases. As Don discussed, we're the land court, so our cases revolve around real estate and land use. And the rules of civil procedure apply, except in one kind of case we do, service members' civil relief cases, which I'll discuss at the end. So the general categories we see are, first of all, zoning appeals. These are appeals of decisions from local boards on variances, special permits, building permit appeals or challenges, subdivision appeals. Frankly, I'm not sure that there's a lot of LAR that's going to happen in those cases because generally individuals who are involved in these are plaintiffs. They're ones who are sought the permit or sought the variance and were denied, or are neighbors who are aggrieved by the special permit or the variance and are challenging it. And generally they'll have consulted a lawyer in order to prepare the complaint because there's very strict time limits and jurisdictional requirements about the time in which you have to file in the land court and the notice you have to give that only a lawyer is going to have knowledge about following. But I can see an instance where perhaps a homeowner got a variance and then a neighbor challenges it, and then the homeowner stuck saying, how am I going to defend my variance, in which there might be some opportunities for LAR. The next type of case we see are just the standard real estate disputes. We characterize them as miscellaneous cases. And these are disputes over title to the real estate, disputes over the boundary, where the boundary line is, disputes over easements over the property, maybe the disputes over driveway, where the driveway is supposed to be located. Maybe it's about an adverse possession or prescriptive easement case where your neighbor built the fence 2 feet into your property and you didn't notice for a long time. And now they're saying, oh, no, it's 20 years too late. We see tons of cases about rights in private ways. I have many of those. So those are cases in which very often one of the parties will be unrepresented or be surprised to find they're being hauled into the land court and don't have a lawyer, in which we would love to see an LAR attorney appear if the party, it's a person that owns a small house, that's their biggest asset. They don't have a lot of money. The thought of having to hire an attorney for this entire case to find out if there is really an easement over their driveway for the benefit of their neighbor, or if they've really interfered with it, is daunting. But getting a lawyer just to come in for the case management conference and talk to the other lawyer can be of immense help. And I think it's a great opportunity for practitioners, for you to get some business in this case. Another common area we're seeing cases is deed and mortgage reformations. These are cases where all of a sudden someone's discovered, and usually it's the bank holding the mortgage, has discovered that the description in the deed is wrong, was not carried over correctly from the previous deed. Maybe there were 2 lots that were described and they left out one. Or the same thing can happen in the mortgage. This is very common, unfortunately, where the description in the mortgage doesn't match the description in the deed. Again, they forgot to describe both parcels that are abutting and that are treated as one, but technically they're described as different parcels, and you left one out. Or maybe they flat out described the wrong parcel. Or maybe their meets and bounds description has been wrong for years and finally someone noticed it. And so now they want to reform the deed. So often I've seen a lot of cases where, say, the original lender or the bank that currently holds the mortgage comes in and says, I got to reform this description. And the property owner is like, well, they agree that they gave a mortgage for their house to this bank and that it was assigned. They don't have a problem with it, but should they have a lawyer? What are their rights? Should I really just flat out agree to this, or is there something going else I should be aware of? But again, can't necessarily afford a lawyer for the whole case. I've had to tell, for the year that I've been on the court, I've had to tell those homeowners, well, you should consult a lawyer. Now I can tell them, you can get a lawyer for just a limited part of this case. And I've had actual people, I've had these homeowners really go, really? I can do that? So this is a real opportunity for you lawyers to represent someone on a limited basis, just to advise them about this kind of reformation case, and maybe come to the case management conference, maybe negotiate a settlement, and prepare an agreement for judgment without being in for the whole case. We also, unfortunately, see a lot of foreclosure-related cases. Some are brought by the foreclosing bank because of title issues or because of their concern that in the wake of Ibanez and Eaton and Bevilacqua, they might not have crossed all their T's. I used to say cross all their I's and dot all their T's, but crossed all their T's and dot all their I's, or that the assignments are not correct and they want a declaration that everything's fine. I'm also seeing a lot of cases post-foreclosure where where the homeowner who's still in the house brings a tri-title case a la Bevilacqua, which is not what happened in Bevilacqua. Mr. Bevilacqua was the person who bought the property out of foreclosure, but I'm now seeing homeowners still in residence bringing tri-title cases. And, of course, they are represented when that happens. But, again, those are cases we're starting to see a lot of and in which you might be asked to represent one of the parties. Those are especially the tri-title cases with after post-foreclosure tri-title cases. It's a very new area that we're seeing a lot of cases on, and we're only now starting to issue decisions about those. I issued one a month ago called Abate versus Fremont Investment and Loan. How that's going to shake out, it's eventually, I'm sure, going to be decided by the appeals court or the SJC. So that's an area that's unsettled and is moving forward. We do registration cases where either original petitions to register title. Those are almost always brought by attorneys, and they move fairly slowly and are complicated. But you might be asked to get involved in those. But any case that after that involves a challenge to that registered title is brought as a registration case. We call it a subsequent case. And that can proceed like any other miscellaneous case with discovery and so forth, or sometimes it gets more complicated. And again, that's an area where you might get involved as an LAR attorney. Now, 3 more specific areas I want to talk about that are kind of separate from our common real estate cases. One are partition cases. These are brought pursuant to General Law Chapter 241. And basically under Chapter 241, co-owners of land, except for tenants by the entirety, have a absolute right to seek the partition of the property from the co-tenant, and to force a partition of the land. And you'll see in the materials the petition for partition that's on our website. And once someone brings that action, it moves forward. And sometimes the kinds of situations in which we see that are either co-owners of property, often unmarried partners who brought the property together and are now splitting up, or siblings who inherited the property from their parents and can't agree on how to manage it. And sometimes it's property that's just sort of sitting around with heirs not completely aware that they owned it until several generations later. There are 5, 10, 20 or more heirs with fractional interests of the property, and someone says, I've been dealing with this property for years and I don't want to do it anymore, so let's just get rid of it. Those cases are covered or done under the rules of civil procedure, but we generally have a specific practice for how we handle those. The first thing we do have a case management conference early on, and the first question we're going to ask is, A, are all the parties with an interest in this property here? And sometimes people don't know. And so we'll ask them to do a diligent search to find all the heirs. And also, are all the people with other interests like mortgagees or other lien holders in the case, because this affects their title. So you have to go and do a diligent search and come back and show us that you've found all the heirs and have all the parties in interest and have given them notice and made them defendants in the case. And if they're people who you can't find an address for, or there's unknown heirs, we'll have to decide if there's going to be publication notice. So once we have everybody in the case and have given them notice, then the next step is to determine, the other thing we want to determine is, while this is all going on, make sure the property isn't wasted, say that the taxes are paid, so that it isn't just taken by the town for lack of payment of taxes, and that whatever basic maintenance needs to be done is continued to be done. So we want to make sure that happens. Once everyone's in the case, we will then have to make a determination whether the property can be divided among all the parties in interest. And if it can't be reasonably divided, it'll have to be sold. And divided means exactly that. You get down and draw a line and say this corner is yours and this corner is yours. But if it's a house lot, we can't do that. Can't carve the house into 4 pieces. If there's 50 heirs with 1/48 interests and 2 24th interests, and that really can't divide it either. In that situation, the statute, Chapter 241, requires us to appoint a commissioner to partition the property. And we do that by just going down a list of qualified partition commissioners. And the commissioner is appointed. Commissioner takes charge of the property, and the commissioner we issue an actual order or warrant to the commissioner, and eventually a warrant for the commissioner to sell the property with instructions about the price to market it at, fallback prices, and so forth. And the commissioner is paid, and the commissioner is paid out of the proceeds of the sale. So one of the things, we are finding that unless it's a small number of people with interest in the land, 2 or 3, inevitably there are people who are not represented, parties of interest who are not represented. And this is a great opportunity for LAR, for someone to get at least some representation in this case. Because people just don't understand. If you get to the stage of the commissioner selling it, you're just not going to make as much money as if you could agree to just sell the property itself and divide up the money. Because the commissioner's got to take his or her cut off the top and has to go through a procedure for marketing it, listing the price, and taking offers. And the final thing is what happens to how is the money distributed after the sale? And it's distributed by the party's interest in the property, but there's going to be some allocation of if parties have contributed to the value of the property through certain improvements. But it's not, you have to go by what's permitted in Chapter 241. It's not necessarily what you think might be fair. It's what kind of credits people get under Chapter 241. So this is an area where people really would benefit from representation. Another area that's troublesome and unusual are tax-taking foreclosures. We have exclusive jurisdiction over those under Chapter 185. These are governed by General Laws Chapter 60. And basically it's when a property tax is in arrears on a property, the municipality has the power to take the property by filing a taking with the registry of deeds. At that point, the town has title to the property subject to an equity of redemption in the property owner to redeem the property back. and to redeem the property back, they have to pay the taxes plus the interest. The interest is statutory. It is 16% per year, which is even better than the 12% prejudgment interest that you enjoy in a civil case. The town has the authority after 6 months after the taking to file an action here to foreclose that right of redemption. And most towns, not all, but most towns do file pretty promptly. But once it gets here, it again goes through a process. It's governed by the rules of civil procedure, but we do have a special process. The first thing that happens when a tax title action comes to the land court is it's sent to a title examiner, an outside title examiner, who will examine the title to prepare a report on who are the parties with an interest in the property, similar to what might happen in a partition action. And there can be several back and forth with the town about these are the parties in interest. Do you have anyone else? There can be some question of whether publication notice is required. But once we've identified, once all the parties in interest have been identified, then they are sent a citation which acts as the summons and the complaint in the case, and the formal notice to the homeowner, to the landowner, that there is this action to foreclose the tax title. Under our LAR rule, we will send the LAR information sheet with that tax, with that notice. That citation will have a return date, which will be the date for filing an answer. If the return date passes without an answer, the town can ask for a default judgment and ask to foreclose. Generally, there are several hearings about this, and people come in to ask what can be done and try to negotiate with the town. These tax hearings are done on Thursdays. They're conducted by our recorder, Deborah Patterson. If a case gets particularly, if there's particular litigation in a case, it'll be referred to a judge. But once a judgment of foreclosure enters, the right of redemption is foreclosed. And the important thing to know is once the judgment enters and the right of redemption is foreclosed, the town has full title to the land. Any equity in the property above the amount owing is gone. It's gone. It's in the town. And this can be, I don't think, often the homeowners don't understand this. And one of the things we're seeing now is there are some municipalities who are, and they have the authority to do this under Chapter 60, will sell their tax titles to private entities, which will then have the right to seek to foreclose the equity of redemption under the same terms as the town would. Until judgment is entered, the homeowner has the right to redeem. Up until the time judgment is entered, they do have to pay the interest. The towns have some power to negotiate, but they have no authority to negotiate away the underlying tax. They do have some authority to negotiate on the interest. This is a long way of saying that this is one of the huge areas where LAR attorneys would be helpful. These folks, by definition, are struggling, because if they weren't struggling, they would be paying their property taxes. And often they can't afford to hire an attorney to come in and litigate this whole case for them. But they could very much benefit from attorneys appearing for a specific event, or giving them advice, or negotiating with the town or the private party that might have bought the tax title. And in fact, we added certain tax events to our appearance form, And the appearance forms that are in your book are the ones that were attached to our standing order. But if you go on our website and use that appearance form, you will see specific events relating to tax cases. For instance, a motion to lift the default judgment. That would be a useful thing for an attorney to be able to come in and do, or a status conference. So this is an important area where I think we would welcome LAR attorneys. The clients would definitely welcome them, and this may be an area where a client can afford to engage an attorney for this limited purpose. The last area that we see are service members cases. And for those of you who ever done foreclosures, you're familiar with this. The Federal Service Members Civil Relief Act used to be called the Soldiers and Sailors Civil Relief Act, back from 1940 or from 1941. Protects active duty service members from foreclosure. Now, the Massachusetts in statute 1990, chapter 496, provided a procedure for banks or foreclosing entities to get a judgment that states that the person they're seeking to foreclose on is not entitled to the benefits of the Service Members Civil Relief Act. You don't need that to foreclose. You can foreclose at risk, but it's not a prerequisite to foreclosure. But it's considered good practice to get this judgment before you foreclose. So lenders who are seeking to foreclose almost always file Service Members Civil Relief Act cases to the tune of 10 to 15,000 cases a year in the land court. I don't know how many. They can also be filed in the Superior Court. I don't know how many go in there. These cases are very different. They're not subject to the rules of civil procedure. They're exempted in Rule 81 of the Rules of Civil Procedure. And they're brought by filing petition. And defendants can answer, and